The following program on KROC is sponsored and paid for by Meshbesher Spence.
The Zach Bauer is in the studio with us this morning. How you doing, Zach?
I'm doing well. Yourselves?
I'm doing well. Good to
Not
see
bad,
you.
not bad at all. What are we talking about today?
Well, we're going to talk about some changes in the drug statute that are going to be effective August 1. And then I've been preoccupied with the State versus Bernard decision that just came down 17 minutes ago.
Oh, my gosh!
So it's like breaking news.
Well, let's talk about that.
I was going to say that probably is maybe more interesting than this.
All
So
right,
bring everybody
so-
up to speed what that means.
So I'm 36 pages into the 67-page opinion. So
Is that what
glad
you're
you're a
reading on your
speed reader.
smartphone?
that's what I was reading on my smartphone as I walked
my
in here
gosh.
today. So, in essence, breath testing is okay without a warrant.
Huh.
That's where we are right now.
Okay.
And I haven't gotten through the entire decision to know what the full reasoning is for that, other than DUIs are bad and lots of people get hurt for DUIs, and so we want to make a special exception. So I'm guessing that's what I'll read more as I get into it. But yeah, for breaking news, for those people that are still wondering about whether or not the refusal statute is going to be constitutional, it is. So
Because the state of Minnesota and the state of North Dakota
had made refusal a crime.
and took it to the Supreme Court, Mr. Bernard.
Mr. Bernard's attorney asked for the United States Supreme Court to review the statutes, and they did that. And their determination was that the state has a special interest in being able to protect people, obviously, on the roadways. I think, as I read further, what I will find out is that they basically adopted what we call a special needs doctrine, which is another exception to the search warrant. Now, in doing that, they did chastise the Minnesota Supreme Court for their decision in the idea of it being a search incident to an arrest. So,
Because the Minnesota Supreme Court, in essence, found in favor of Mr. Bernard.
no, the Minnesota Supreme Court found in favor of the state of Minnesota, but they found in favor of the state of Minnesota on the basis that, for instance, when you're arrested, officers can pat you down to make sure you don't have weapons. They found that that's the same as going inside of your mouth for breath.
Okay.
Which is not what a search incident to arrest should be.
Okay.
It should be just for officer safety.
Okay.
So what they basically said is, no, Minnesota, you got it wrong in the reasoning. You got it right when it comes to the fact that it still is, it still does not require a warrant, but it's based upon kind of a special needs exception. So as I get into that a little bit further, next week I can probably maybe give us a full rundown of that information. But
So bottom line is, an officer
an officer absolutely can.
It is constitutional for
He
them.
can request you to say, take a breath test, and if you say, I'm not taking a breath test, that's going to be a crime.
Okay.
And so now, going back to Mr. Bernard, this does not vacate his conviction, because he
No.
was ultimately convicted, correct?
Yeah, he was ultimately convicted, so it will not vacate his conviction, and
Okay.
he will serve out the rest of his prison sentence, I'm fairly certain.
Wow.
So
All right.
so that's breaking news.
Yeah.
Wow, you've got
As
it going
happens,
on.
right here on KROC AM.
Any show prep that you had done goes out the window
I know, I
when
was
the
gonna
Supreme
say,
Court
I
comes
was gonna
along.
say.
However, we
Those
still have a
guys.
few minutes here left for your show prep. So, drug statutes. Okay, what changes are happening on the 1st of August?
So major changes in the sense of what used to be how we knew first degree, second degree, third degree, fourth degree, fifth degree. So there's 5 different degrees of different drug crimes. First degree being the most serious, fifth degree being the least serious. Long and short of it is the weights that a person has to have for a sale crime are going to increase. It's going to be more difficult to be a first or second degree offender than what it used to be. There are going to be some aggravating factors that are going to be added to it so that people that are really doing a lot of sales, there can really be a hammer to them.
So the dealers.
It's the dealers.
Yeah.
But for the people that may be primarily users, there's going to be a significant reduction in what those sentences are going to be. And what used to be what we call mandatory minimums, things that the court could not depart from, are going to go away, except for first and second degree sale crimes and some possession crimes.
And this is what I know the County Attorneys Association have been pushing for, and a lot of just to get, it'll help clear up the prisons a little bit because there's so many drug users that were there. They can go down to drug court for that matter.
So there's going to be an aspect to be able to go in drug court, and sometime I'm going to try and get Judge Wallace in here with me one of these mornings so we can talk about drug court, because that's up and going now in Olmsted County.
Yeah.
So, but absolutely, it's going to focus more on punishing the people that are doing the sales, not punishing as much people that may be doing some sales, but primarily it's based upon use. And there's also provision in that allows for people that are currently in custody and have served a certain portion of their sentence and were there because of possession, not because of sale, to ask for some type of relief to be out of prison. So,
all right. Well, if anybody has any questions, needs an attorney, how do they get in touch with you?
They can contact us at 507-280-8090 or visit us online at www.meshbesher.com.
Zach, have yourself a great week.
You guys too.